It's a tremendous privilege to introduce our speaker this evening, the Right Honourable Beverley McLachlin, and the topic of her lecture, which happens to be the 30th in the Frontlines of Democracy series that Sergio just mentioned. One of the most distinctive features of modern democratic politics is the central role played by constitutions in determining where power lies, how it should be exercised, and what makes it legitimate. Constitutional democracies are defined by the separation of powers, a series of checks and balances, and the rule of law. Yet how power is distributed amongst these three main branches of any polity varies significantly, as we know. And one of the most enduring questions in every democracy is to decide what specific powers the judiciary should have. Over the last 4 decades, the power of apex courts has grown tremendously across the world, and era legal scholars have often described as the new constitutionalism. Many support the enhanced role given to the highest courts of the land to articulate constitutional values, protect civic rights, and check executive power. Governments have even asked the judiciary to address deeply contentious issues that they find hard to resolve, as we know here in Canada. But others decry what they call the judicialization of politics in our democracies, and instead they advocate greater deference towards the supremacy of Parliament. These debates provide a backdrop to more troubling developments over the last decade. Many democracies have experienced an erosion of the norms, institutions, and practices we associate with good democratic governance. The clearest manifestation of this is backsliding, the rise of political leaders that aggrandize executive power, challenging the prerogatives of the judiciary and the legislature. Some even attack the idea of constitutionalism itself. So what distinctive features of Canada's judicial system have protected its independence, the separation of powers, and the rule of law in our democracy? How does Canada compare to the United States, which might be on your minds? Are the norms, rules, and practices that distinguish our judicial system and the wider democratic polity that we live in adequate to address the challenges we face today, which range from populism and mistrust to polarization? As the longest-serving Chief Justice of the Supreme Court of Canada, the Right Honourable Beverley McLachlin is uniquely placed to confront these questions, amongst others. Educated at the University of Alberta, she trained in philosophy and law, called to the bar in Alberta in 1969 and British Columbia in 1971. From 1974 to 1981, she taught at the University of British Columbia as a tenured associate professor of law. Her judicial career began in 1981 with the Vancouver County Court, followed by a series of higher appointments in the Supreme Court of British Columbia and its Court of Appeal. In 1989, she was sworn in as a Justice of the Supreme Court of Canada and then appointed its Chief Justice in 2000, a position she held until 2017. A recipient of over 35 honorary degrees, Chief Justice McLachlin is a companion of the Order of Canada, amongst many other awards. Her numerous publications include 3 best-selling novels, which I was surprised to discover, having returned to Canada in 2019. Full Disclosure, Denial, and Proof, and they're available in the back. And a memoir, Truth to be Told, which won the Writers' Trust Shaughnessy Cohen Prize for political writing. Chief Justice McLachlin will speak for about 30 minutes. I'll then start a conversation with her to explore some of the issues raised in her lecture before we open up the floor to your comments and questions. Please join me in welcoming the Right Honourable Beverley McLachlin.
Thank you all for being here tonight. It's wonderful to see so many people interested in the courts, the rule of law, and the issues we're facing in 2025 as we move forward in a very uncertain world. It's really a great privilege to be here. Last time I was here, I was flogging my latest novel, and now I'm talking about courts and the rule of law. I thought I would broaden the subject tonight from just talking about the judicial system and courts to talking about what is on my mind and what I think is on a lot of people's minds as we watch what is happening in the world. And that is democracy, which we cherish so much, so highly, and the rule of law. As a lawyer and a judge And as a fervent believer that democracy is the best system of governance in the world to maximize human potential and happiness, I've been thinking a lot about the relationship, and that is what I would like to focus on for the next few minutes. I will get to the Canadian situation as I move toward the end of my comments. We used to say we live in interesting times. I think now we say we live in parlous or dangerous times. We once took the global ascent of democracy for granted, no longer. The reality is that democracies around the world, after heady expansion after World War II was finished and people decided that never again would we allow the atrocities that took place in that time to return. Since 2011, actually, according to Democracy Watch, democracies have been failing around the world. And even the rock-solid foundations, or what we thought were the rock-solid foundations of functioning liberal democracies, have been heaving under the stress of seismic change. So what happened? Why are democracies so long thriving and providing good governance on the whole, enhanced standards of living, enhanced standards of justice? Why are they failing and sometimes foundering? Our op-ed pieces are filled with answers. The failing middle class, the increasing gulf between haves and have-not, misinformation and the web, the shattering of trust and the fear the world is spinning out of control. All this resulting in, quote-unquote, the end of truth, polarization, and the division of democratic societies into tribes unwilling to accept that anyone but their tribe and their champion should govern unhampered by legal limits. But I think these phenomena are only part of the picture, the symptoms of a deeper democratic malaise. Democracy has been around for a very long time and has faced many challenges. To blame the fragility of democracy on social changes, however profound, risks begging a more basic question. What does democracy need to overcome the social shifts of globalization and the internet? This brings me to my subject this evening, which, as I've said, is mainly the rule of law and democracy. I will argue that the rule of law, in a deep cultural sense, has been the foundation which allowed democracy to weather the challenges it has met in the past. What is different about our current situation is the aggressiveness of the attacks on what we thought were settled ideas of the rule of law, and the warm reception these are receiving amongst many parts of society. And all this, I believe, is cause for deep concern for those of us who cherish democracy. I believe that while democracy rests on diverse pillars, from fair elections to a free press and many more, without the rule of law, it cannot be long sustained. Increasingly, the rule of law finds itself challenged by those who seek to undermine democratic norms and install strongmen and oligarchs unconstrained by these norms. That should not surprise us, for as I shall argue, the rule of law and democracy have from the beginning been joined at the hip. The rule of law is the other face of democracy. Democracy at its base means a system of government by the people. The people are sovereign. Unlike in autocracies or party systems of governance where power flows from the rulers down to the people, in democracies the citizens are the basis of power. They are the sovereign, and they are the source, theoretically, of all power. Power flows from the bottom up, from the people through their votes to their elected designates, whose function it is to make the laws for the people and supervise their enforcement. Autocratic forms of government can manage with what scholars call rule by law. That is, simply pass the laws and the edicts and then tell everybody they have to obey and make sure they do with force, if necessary. But democracies need the rule of law, which upholds the guardrails of democracy to ensure that power conferred on elected officials and those they employ stays within constitutional and legal norms. The rule of law, or important features of it, have been part of democracy since its earliest iterations. For the ancients, two ideas central to the rule of law emerged. From the ancient Athenians came the idea that the citizens are sovereign, that they make the laws through their representatives, enforce the laws through their representatives, which was a very novel idea when you think about it, having come in the midst of a society which was used to chiefs and kings and rulers, where the law was handed down. So this idea that the people make the law and are the source of the law was very unique. But then the Romans took it up and they added another second central concept, which was that everybody is bound by the law. Nobody is above the law. And this meant a lot to the Romans. Often particular leaders or generals would flout the law, but they kept that theme steady in their writings and in their jurisprudence, and they wouldn't let it go. And we know the Roman Republic lasted for about 500 years, and then it shifted, it was overtaken, it fell in the time of Cicero to the Caesars, who were top-down rulers in every sense of the word. But it is interesting that when Augustus Caesar, the first Caesar in the first clear break with the Republican tradition, he maintained as some of his first acts that he was bound by the law, because in order to get legitimacy in that Roman society, where they'd been fighting bitterly for some time over whether they'd be a republic and whether they'd let strong men take the role of leader, to maintain legitimacy, he needed to say, I'm bound by the law. Now, sometimes that was the law the way his jurists wanted it to be, and it was often flouted. But that idea that even the emperor was bound by the law lasted until, I think, 274 CE, Diocletian's age, which was a long time in the empire. And then finally it was said officially that the emperor was the law. And from that we got the idea of divine right of kings, which was that they were the law, the source of the law, and so on. Well, we all know that ultimately the Roman Empire fell and the Middle Ages came, and for a long time nobody thought about these two seminal ideas that the ancients had had. First, that power, sovereignty could come from the people. It could be a bottom-up affair. And second, that everybody, even the highest ruler, is subject to the law and the limits of the law. So a long time passed when only kings and chieftains and so-called emperors ruled according to their whim. And you can include that in much of Europe, there's the Catholic Church. And then the Renaissance came, times changed. People had forgotten about the Greeks and Romans, and then they discovered Cicero's writings, which had been miraculously preserved. And Cicero actually was killed, assassinated, for his defense of the Republic in its dying days. And he wrote very eloquently about these democratic ideas and about the law. He was a great lawyer and a great orator. And suddenly people started to get interested in the law. And they started to get interested in what the law could do and how the law should relate to the rulers. And this intellectual ferment percolated along until in the early 1600s, the English Chief Justice, Lord Edward Coke, stood up to James I and told him that he, too, was subject to the law. James I believed stolidly to the core of his foundation in divine right of kings, and to him this was a great affront, and he engineered a confrontation with his judges who were telling him that he couldn't do what he wanted to do because the courts had said no. And it must have been quite a dramatic thing, because he summoned all the judges and the Chief Justice to appear before him in court, and he gave them he was very learned, James I, and he gave them a long lecture on divine rights and what their duty was, and which was to do what the king wanted. And one by one, the judges acquiesced and bowed on the knee and said yes. And then they came to Edward Coke, and he was a stubborn fellow. He said, "I will do what my duty requires." Well, it cost him his job. I mean, it could have cost him his head, but that was spared. And he lost his job as a judge and as Chief Justice, and there was no independence of judiciary as we have it now. And he took to writing and lawyering, and he kept fomenting these ideas, and they were taken up by a legal scholar called Blackstone, who had enormous influence, particularly in the United States. And moving forward, I know this is way too much history and the eyes are glazing over, but we're going to finish very quickly. In the United States, a new republic was proclaimed in 1776, and these ideas of governance were cast into the American Constitution. 3 branches of governance, legislative, which is Congress, executive, headed by the president, and the judicial branch. And ultimately, Chief Justice Marshall, the first Chief Justice, held that upheld the principle, which has stood ever since, that when the judicial branch rules that a law passed by Congress is beyond the Constitution, unconstitutional, then it is unconstitutional, and it must be obeyed. Whatever the order of the court is, must be obeyed. A principle which has been by and large accepted by all American presidents since that time, even in very difficult eras. And President Andrew Jackson who was limited by the Supreme Court of the United States when he was driving indigenous peoples ever further westward and dispossessing them, was reported to have said, "Marshall has made his order, now let him enforce it." Whether he ever said that, scholars debate. But the idea is clear, that tension, and what has kept it going, and what has kept democracy together is this convention that the law is important. The judicial branch is the third branch of government, and and its orders must be obeyed. More of which later. Well, what about democracy? Democracy, as I mentioned, is a system of government by the people. And so there are many definitions, but for now, let's just stick with that. But how do we define the rule of law? Fundamentally, the rule of law means government in accordance with fundamental constitutional norms that define how the sovereignty of the people is exercised by the elected representatives they choose. The rule of law is not just a set of rules that people are expected to obey, but deep and permanent principles and values that define the rights and obligations in a democracy and ensure respect for rights and accountability for the exercise of power. And I'll come back to that. The accountability for the exercise of power is absolutely central to the rule of law and its interaction with democracy. But let's just digress for a moment and talk a bit about the rule of law. Scholars offer two different conceptions of the rule of law, one formal and one substantive. The late Professor Joseph Raz likened the rule of law to a sharp knife required for an effective legal system. This formal definition, though, tells us nothing about how the knife is used, for good or ill. Others have taken a substantive or thick view of the rule of law. Lord Thomas Bingham, Chief Justice in England a few decades ago, in his seminal book on the rule of law, set out 8 basic principles it encompasses. Accessible judicial systems, resolving disputes according to rules and not whim or discretion, equality of all before and under the law, human rights, dispute resolution, fair trials, and compliance with international legal norms. But most significant for our purposes is his 4th principle, pertaining to the exercise of power. Bingham wrote, "Ministers and public officers at all levels must exercise the powers conferred on them in good faith, fairly, and for the purpose for which the powers were conferred, without exceeding the limits of such powers and not unreasonably." That is what the rule of law requires. So you give the power to these people, but the rule of law says, wait a minute, don't get too excited. There are limits on what you can do, and those limits are defined by the Constitution and will be monitored and explained by the judicial branch. In defending the fact that the rule of law is more than just a set of rules that everybody has to obey, Lord Bingham concluded, and I quote, "A state which savagely represses or persecutes sections of its people cannot be regarded as observing the rule of law, even if the transport of the persecuted minority to the concentration camp or compulsory exposure of female children on the mountainside is the subject of detailed laws duly enacted or scrupulously observed." In other words, there's an underlying basis of morality and human rights and respect for the individual that underlies the rule of law, the same respect for the individual and dignity that underlies democracy. So they spring from the same source. The rule of law in this thick sense means more than fine constitutions and elegantly drafted laws. In How Democracies Die, written in 2019 in the era of Trump 1, Levitsky and Ziblatt review democracies in Latin America and elsewhere that have failed in recent decades, despite fine systems of law on paper. And they warn that constitutional safeguards don't always preserve democracy. Even in America, they wrote, only the thin tissue of convention prevents American presidents from capturing the referees, that is the courts, and marshaling them against their opponents. Citing other scholars, they warned that at that time, Trump won, that the constitutional and legal safeguards of democracy would prove fairly easy to manipulate in the face of truly transcendent value. So it's not enough to just have a fine constitution that says these are the powers you have, etc. It's not enough to have a fine set of laws. So what more do we need? I believe we need a deeply entrenched culture of the rule of law that is part of the way the people, as members of a society and a nation, see themselves and conduct themselves. Mere words of paper are not enough. The people of the country must accept the precepts of the rule of law, and they must somehow expect that they will be respected in order to make the whole system works. The presence of this culture of the rule of law or absence explains why some democracies are highly resistant to manipulation while others are not. Mature democracies possess a deep culture of the rule of law, set in a matrix of custom and unwritten rules. These include countries like the United Kingdom, Canada, and the United States. Democracies lacking this deep culture, like some that emerged after the dissolution of the Soviet Union, have proved easier for strong men to undermine and manipulate. The rule of law in its deep cultural sense serves to secure democracy. So a pivotal issue for any system of governments is how you're going to enforce the law. In autocratic systems, the power of the state from on high accomplishes this. They send out the police, they send out the armies, the law is enforced because people are in fear of it. But how does that happen in a democracy? Are these sovereign people at the bottom going to get up and enforce the law? They don't have the means, and nor do they have the power to do so. And how can a democracy ensure that once it gives power to individuals by electing them, that they will stay within the guidelines of the Constitution and the law? It's easy to say that laws must conform to the Constitution and that public officials must exercise the powers conferred on them for proper purposes and within the bounds of the law. But without mechanisms to hold them accountable, the fine rules will amount to sound and fury, but signify nothing, to borrow the language of Shakespeare. I call this the problem of democratic accountability. And how can democracies solve it? Democracies hold those exercising power on behalf of the people. The answer is by a twin set of principles. The principles of unbiased adjudication by independent jurists and the principle that everybody in power obeys the law, submits to the law. The first requirement of democratic accountability brings us to the courts, which I was supposed to be talking about all the time, and the need for an effective justice system. Citizens and prosecutors must be able to access the courts to bring complaints of unlawful exercise of power to independent courts, and they cannot be under the power of the executive branch in order to do this job. And they bring their cases to independent judges who decide whether the laws or the executive acts violate the Constitution and the legal norms that govern the country. The second requirement of democratic accountability is that everyone exercising public power, whether the highest president or the lowest public servant, must respect and comply with court decisions, unless they are set aside on appeal or lawfully suspended pending appeal. And I believe that those two principles together guarantee that democratically conferred power is exercised democratically, that is, in accordance with the Constitution and the law. We are now witnessing, south of the border, assaults on these principles, assaults that I hope fervently will not prevail. The executive has resisted or seemed to resist obeying court decisions it disagrees with. Independent judges have been vilified for making decisions the politicians don't like, and their removal has been demanded by politicians, drawing no less than a rebuke from Chief Justice Roberts. We read in the press that judges who are just doing their job are receiving death threats online and now require security, and that the President has issued an executive order that threatens disciplinary proceedings against lawyers who oppose the administration. And yes, a strong and independent bar is essential too to the rule of law and democracy. Scholars are introducing new arguments aimed at pushing the limits of executive power ever outward. As I have said, the United States possesses a deep and impressive culture of the rule of law. Is it eroding, and with it the power to hold to account the exercise of government power? We watch with apprehension. The rule of law, in the deep cultural sense I have described it, is fundamental to maintaining democracy. It follows that democracies must act vigilantly to strengthen and maintain the rule of law if they want to keep themselves strong and democratic. And it may be useful in this context to consider how the rule of law can be undermined and eroded. And there's a lot of ways that, if we had 5 or 6 hours, I could give you all the details, but let me just give you some of the ways this has been accomplished in different failing democracies around the world. Hobbling the work of prosecutors in holding power to account. Undermining the independence of judges through administrative actions, like depriving them of judicial resources and proper salaries. Politicizing the courts by appointing judges on the basis of their perceived political views, who they side with, rather than merit. Politicians publicly castigating judges, removing independent judges and replacing them with compliant judges, setting up alternative tribunals for special matters, which then takes them out of the purview of the courts, creating constitutional or legislative carve-outs from judicial review, which deprives people of the right to challenge breaches of their rights and excesses of power in those areas. Condoning corruption. Thankfully, that does not feature as a problem in many of our systems, but it is a problem in some democracies. Failing to comply with judicial decisions or refusing to comply. Discriminating against, deporting, or killing people without due process of law. Those are just some of the ways the rule of law in the last 2 decades has been undermined. Sometimes the undermining is blatant, but other times it can be subtle and slow. Democratic governance requires us to be alert to incipient slippages in the rule of law and be quick to correct them. Before concluding, let me turn to the rule of law in our own democracy, Canada. Canadians are sometimes complacent about the state of our democracy and the rule of law, with some justification. In Canada, court orders are enforced without question, and legal decisions are respected. In Canada, the legislative and executive branches respect the role of the judiciary and do not interfere with its work. I can attest to this as someone who worked in the federal courts for almost 40 years and as Chief Justice as well. Our courts are independent and they are respected around the world for the quality of their work. But we should not be complacent. Not long ago, Canada's capital was held hostage for 3 weeks by groups driven by the same memes of freedom from governmental limits and court constraints that threaten to undermine the rule of law south of the border, including contempt for the law. Carried to extremes, such actions have the potential to destabilize the rule of law and democratic governance. But more broadly, Canada has work to do in ensuring better access to justice and with it, public confidence in the justice system. In recent months, legal and public press has catalogued long delays in Canada's criminal and civil justice systems. Justice in Canada is now widely stated to be slow, expensive, and for many ordinary women and men simply inaccessible. The principles of equality and respect for human rights that inherit in the rule of law suffer when people cannot turn to the courts for justice for whatever reason, be it money, be it time, be it simply getting in. Ultimately, this situation has the power to undermine public confidence in the rule of law and democracy's ability to deliver justice. And when that happens, people turn elsewhere. They turn to different ways to get their problems solved, and that can be completely undermining of the rule of law and democracy. And I mention this because it's something to watch. Canada must wrestle with its own judicial carve-out, the notwithstanding clause in our Constitution, which allows legislatures and Parliament to override judicial decisions affirming charter rights for a renewable period of 5 years. For decades, this clause was not much used outside Quebec, where it was invoked to insulate language and cultural rights from judicial review. But its use has seen something of a resurgence in recent years. An important question for democratic accountability is being debated by scholars and judges in cases wending their way to the Supreme Court of Canada. Can a legislature insulate itself from judicial review simply by invoking the clause at the time of enactment over a whole statute, blanket claim? Or should the clause be interpreted in such a way that it requires the courts to be given an opportunity to rule on charter rights at stake before the legislature can invoke it, thereby allowing the public to better decide whether the override is justifiable and enhancing democratic accountability? Once more, we watch with interest. Finally, I think it behooves us as Canadians to avoid normalizing breaches of the rule of law occurring here or elsewhere. Commentators in the United States have noted that they've talked about what we call big lies. Lies so big that they seem real. And you say, what? And then you start to believe it. But the commentators have noted that the more often these big lies, everybody says, that can't be, no. The more often they're repeated, the more people come to believe and accept them. They get into our social media, they stream around the world, and finally they get into our conscious and subconscious, and we start no longer, we don't say that's not so. We tend to accept them. We should reject the big lies, and there's lots of them, about the rule of law and the justice system that are circulating. Big lies like the mantra that judges have no more power, and this is a real one, to limit the power of the president than they have to tell generals how to conduct a war. A pronouncement of the Vice President of the United States a while ago, although he qualified it by saying he was talking about valid judicial decisions. Big lies like independent prosecutors conduct politically driven vendettas. Something easy for an uneducated public, people who have trained in the law, to accept. Why wouldn't they? Big lies that lawyers who speak the truth to power are somehow acting unethically. It's hard to keep track of the big lies. They're constantly mutating and multiplying, but we can't ignore them. Big lies aren't constrained by logic, and they're not constrained by borders. And we as Canadians must be very careful not to allow them to invade our consciousness and become part of it. I will now conclude. The rule of law, in summary, is inexorably bound up with democracy and essential to its maintenance. The values that imbue the rule of law are the values on which democracy rests: human dignity, equality, the right to justice, and the principle that no one, however high or powerful, is above the law, and that all those exercising power are accountable to the people on whose behalf that power is conferred. Remove any of these values and democracy is weakened. Remove them all and it may founder. Is governance possible without the rule of law? Yes, but it won't be democratic. It will be rule by law, not rule of law. And it will not provide, I believe, the stability and justice that democracy has provided for countries like ours over the past 2.5 centuries. The rule of law and democracy are challenged in this moment, perhaps as never before. But when I grow fearful, I remind myself of what Thomas Jefferson, the third president of the United States, wrote to his compatriot, John Adams, as they, both nearing the end of their days, despaired of what was going on in the republic they had founded. Jefferson wrote, "The flames kindled on the 4th of July, 1776, have spread over too much of the globe to be extinguished by the feeble engines of despotism. We live in an era when democracy is being challenged as never before by the engines of despotism. With the help of the rule of law, I believe that we can ensure that they do not extinguish the flames of democracy." Thank you very much.
Thank you very much for a whistle-stop history lesson.
Sorry.
From the Greek republics in the Roman state to the present. And I'm glad that you gave the lecture you gave, which was focusing on the rule of law, which was at the heart of the questions we've all been grappling with. So I've listed already 9 questions, but I'm going to start with just a few, because I know there's so many of you here as well, and we'll have many questions. So when I think of the rule of law, and particularly, I won't call it in some countries the crisis of the rule of law, but questions about the rule of law, the willingness of people to interrogate the legitimacy of the rule of law. I sort of think of it in sort of at least 2 spheres when you think in terms of democratic politics today. So one has to do with how people view the courts in their democracies. So you, towards the end of your lecture, you talked about Canada, and you said our court is we have issues, and we'll get to that later in conversation. But you say, it's independent, it's seen as fair, it respects the judiciary and the executive branch. But in a number of countries, as you were alluding to, certainly in at least the last decade, more. We all think of the United States, of course, but there are others where the courts seem to have become politicized, either through the appointment process or the way judges act, perceptions that judges are corrupt. And so I think a first set of questions I had were, there are fundamental questions that we always ask, but I'd like to ask you, given the experience that you have had and the role you have played, which is, I think a lot of questions today about the legitimacy of courts to rule have to do with sort of three classic questions. What's the source of their authority, given that they're not elected? So what's very striking is a lot of the elected leaders who attack the courts or the rule of law, constitutionalism, say, well, I have a mandate. The people elected me. Who elected the judge? So that was the first one. So what's the source of a judge's authority, a court's authority? The second is, who guards the guardians, the classic question. So if the Supreme Court in a country is the final arbiter of the meaning of the Constitution, what happens when what happens if we disagree with their ruling? And then the third one, which you've talked about, democratic accountability, I think that's another one that comes up, which is, well, how are judges and courts held accountable? And of course, there are answers to all these questions, but I wanted to ask those questions to you.
They're really pertinent questions because they're at the top of everybody's minds, and we hear it all the time. So I'm really glad you raised those questions. The first is, judges aren't elected, so therefore they don't have legitimate power, lack legitimacy. Well, the legitimacy comes from the agreement of all the people, as metaphorically expressed through the Constitution. As I argue, you cannot have a game of hockey without a referee. You can't have a corporate system without some rules and enforceability mechanisms. And you can't have a democracy without some way of resolving first of all, resolving the disputes that divide people in a way that everybody will accept and get on together and go on together in life, and resolving those constitutional boundary issues between sometimes executive and legislature. Like there's lots of issues now between Congress and the executive in the United States. Somebody's got to resolve those. And that is the court's job. And so that is why in England and in other parts of the world where democracies have grown up, going back to history, you always see with that growth of democracy a court system that is more or less independent. And these jurists fought very, very hard, not because they wanted, in England, for example, in the old times, people like Edward Coke, not because they wanted the power, but because they thought this was the only way they could have a decent government that was responsible to the people, because people got tired of the tyrants and the chieftains and the rulers who could execute people at a whim, and they wanted something that would be more that would be fair, that would allow people to have their say, that would allow them to ensure accountability. So they devised this system in their unwritten and then in the U.S. written constitutions, and we have it now embedded in our Constitution, that you do need to have an unelected body who are totally biased, who will take a scholarly and fair look at these questions that will arise in any society. And so that's why we have decided what we have. The legitimacy comes from the Constitution. That's the legitimacy question. Then the second question is, what if the courts go completely off the rails and don't do their job properly? Was that the second or the third? Anyway.
Yes, that was the second.
Yeah. Well, first of all, we have very strong conventions that have prevented that from happening in most of our democracies. You look at the United States, have the judges ever gone completely off the rails? I'm sure there's some people who say they don't agree with this decision or that decision, but by and large, the courts have tried to follow the law and administer justice. And certainly in our country, we have these very strong traditions, and judges who don't act judicially, of course, there are appeal mechanisms. So you get a judge who's off the rails, well, the appeal court will say, sorry, and then you go to the Supreme Court of Canada, and then the public debates all this, and in the meantime, you get a lot of clarification. And so we haven't seen the phenomenon of power-hungry judges racing out there to dominate the whole political sphere. And I don't think we will under the conventions. One thing you have to realize is that you can imagine all sorts of things happening, but in a democracy that has this deep culture of the rule of law, these conventions have the force of law, and they prevent judges from acting in autocratic ways. The closest historical example I can think of is when, after the Depression and the United States was in a terrible economic situation, and President Theodore Roosevelt conceived the New Deal, and he had Congress, he encouraged Congress, and Congress did pass a series of laws to pull the country out of the Depression and restart the economy and so on. And at the time, the Supreme Court of the United States was very conservative, and they started knocking down these laws, one after the other. And so people started to get very angry at the court. Roosevelt, interestingly, did not say we're going to get rid of the court. But he was pretty desperate. And he floated the idea of packing the court. What would that do? How do you do that? You appoint a bunch of people who you think will vote with you, and they can outvote the others. Well, that is not a really good idea. But the threat was enough that those justices who remained realized they had to accord more respect to the other branches of government, and indeed they did, and they got the legislation through, and the New Deal took place. So, the system is complex, it's subtle, but it corrects itself in different ways without violating those basic norms that say you do have to obey the orders of judges. Roosevelt knew he had to, but he had to find a political way to get around it. Would that have been good? I think court packing would be a bad thing, and I hope we never, ever have to get there. In our Canadian Constitution, though, we have quite a few checks. They do not oust judicial review, apart from Section 33, the notwithstanding clause. But, we have a pretty good system of checks and balances, and hopefully we can survive harmoniously in this way.
So one of the checks that's on a judge or a court, judiciary as a whole generally, is that, of course, you have to give reasons, and the reasons have to comply with the Constitution and the law. They're public reasons. You may have your own private views on something. You may even have a strong moral intuition about a case. There's a very interesting passage in your memoir when I was reading it last week. It's a wonderful phrase where you said, a judge may hear a case and instinctively, strongly, intuitively think, this is what I think of this case. But as they start to go through the facts of the case and see what legal principles apply to the case, what precedents exist, in the writing of the case, you have this phrase you say judges use, that it just won't write.
Yeah.
This idea that you can start with a very strong conviction of what you believe, but as you're trying to see how does it fit with the law and the Constitution, you begin to wrestle with yourself in a sense, and you realize that you actually have to change course. So I can see that there's a publicness to what judges have to do.
Yeah.
And you also talked about, in any case, legal scholars, the public, others weigh in on this. And I guess as a judge, in you have that in mind too. You're not just deliberating with your
Yeah.
colleagues in the court.
Yeah.
Is that?
Yeah, I agree with that. And before I go there, I just want to say there's a preliminary constraint, and that is that as a judge, you are bound to listen to both sides. So you may walk in the courtroom and see this absolutely, you think, heinous person, but you have a duty to listen to everything she says or he says, and to consider those arguments and their side of the story. And you have to commit yourself to that as a judge. I called it putting yourself in the shoes of each of the contenders by an act of imagination. Just as an actor would, playing whatever role, villain, hero, whatever, puts himself in that situation and makes himself or herself feel how it would how you'd act in that situation. And you know, sometimes when I was judging and somebody'd done something, everybody said that was wrong. They shouldn't have done it. When you got deeply enough into it, you started seeing that, you know, it was, you were looking at it from one perspective, but there was another. So the first thing a judge has to do is just look at a problem from both sides. And that, if you really make yourself do that through a conscious act of imagination, it helped me a lot to make sure I didn't go down some rabbit hole and simply act on my initial assumptions. Then you have what you describe, you have this discipline of having to work it all out through the principles and the law, and that is very constraining. And then finally, you were saying, I've forgotten your last of your question there, but anyway. But there are a lot of constraints on judges. Yes, the public discussion and so on. You know, judges don't act in a vacuum. There's a whole system behind them, what the lawyers are arguing, the precedents, the legal scholarship and articles, and certainly at all levels, but at the Supreme Court of Canada, we were constantly reading and absorbing different points of view and different possible ways of coming at a problem, and so it becomes not a kind of executive act. It becomes a really judicial act, and you're trying your best to you know, create a decision that will be fair, that will work out in the future, be practical, capable of implementation, and uphold the basic principles and values that we have.
So before I turn it over and open it to the floor, I want to ask one more question, and maybe it has to do with our court, in reference to what's happening in the United States. So you talked about how the United States, Canada, Britain, other countries have a deep public culture of the rule of law, but now we're seeing a lot of challenges and threats to that, certainly in the United States and other countries as well. We saw incidents even in Britain where the Supreme Court had to tell the Prime Minister at the time, Boris Johnson, you can't prorogue Parliament, and he had to listen, right? So you had that check. But in Canada, you talked about the risks we face, and you mentioned, of course, too, challenges, long debates over the notwithstanding clause. But the other one I wanted to talk about was access to justice. You know, in India, which the country I study more than any other for a long time, and I've studied the court there, which is a phenomenal court in many ways, but also a controversial court in some ways, one of the most powerful in the world. The backlog of cases, the fact that in India you don't have to go up through the judicial system, a citizen, anyone in this room, if you're in India, could go directly to the Supreme Court of India. And the rules of standing were relaxed. The judges were very proactive in reinterpreting the Constitution in the early 1980s. There's a very dark joke. Due process is the punishment, right? Because it takes too long. As you said, the law can be slow and expensive. It can be time-consuming. It can cost a lot of money. And in fact, that's one of the things we do see happening. Sometimes somebody will take you to court, as we know, strategic litigation against people say, well, we're going to take you to court because we know we'll bound you up in the court for so long. Even though you might be in the right, by the time, different things happen. By the time the court even rules in your favor, you may have been ruined, your organization may have been shut down, and these kinds of things happen. So in Canada, when you see this as a challenge, access to justice, what remedies you think are important?
Well, we do have a real challenge on access to justice, and I've been talking about this for a long time. There have been some improvements. People are aware of the difficulties, and they take many, it's a hydra-shaped problem, and take many forms. A lot more attention is being paid now to getting legal services to poor and marginalized people who could never have dreamed of, going into court, a woman, and fighting for custody when the marriage broke up and she would have no resources. And now, there are agencies and often publicly funded, not necessarily just by the government, to help people, and there's a lot of good work being done. So I want to be positive about Canadians supporting access to justice, but I do believe that we need to really take a hard look at making our principal courts, which are the the trial courts, the courts of appeal, doesn't apply so much to courts of appeal, but in our country, more efficient. We've got wonderful courts, we've got wonderful judges, they're learned, they're ethical, they write great sets of reasons that are admired around the world, but it just takes too long. And so people don't go to court or can't go to court. And we can change this. I've said we live in our legal culture in some ways is in a 19th century Victorian mode. Everybody goes to a courtroom, you stand there, you tell all the stories, you go ahead, and the procedures, even before you ever get to trial, take years. These can be streamlined. There are lots of models of dispute resolution that adopt whether it's arbitration or international dispute resolution models. You can, with some thought and effort, you can make things much better. And in England, there's a scholar, Richard Susskind, who has written a lot about this, and his model may not be perfect, you may like it, you may not, but he says, everybody who has a problem, whether it's a family problem or a legal problem, should be able to go to some sort of registry and talk to somebody and then get directed. And maybe with the help of people who can advise as to what the law is or what their situation is, or online mechanisms which are quite effective for resolving disputes of ordinary bread and butter variety. People can each put their positions in, and some sort of referee looks at it, and they have conversations, and very often the thing can get resolved. That's a way of getting justice. It's not going to court. But Susskind thinks that a lot of problems can be headed off at that level, and some of the tribunals we're setting up are trying to do that. But then he says it should be linked to the court system, so the ones that raise real issues of law can go further, and then you'd have to build a system that sustains it financially and so on. All this, I believe, can be done, and I think we could use the digital technology we have now to really enhance the way we organize our cases and avoid wasting time and lawyers standing around in rooms for hours waiting to get called, and scheduling and just simple matters like that. Now, it would take probably, and I think it's being done in this province to some extent. The Supreme Court here has really been doing a great job of looking at its trial processes, and it's kind of a leader in this. So Chief Justice Morowitz has been a real, to my mind, hero in being willing to take a look at how the Supreme Court is operating and just putting in reforms. That's how we start. That's how we make it better. But we should really put more effort into it. And one of the problems is that our courts are starved for money. the peculiarity of our Constitution is that, I'm not talking about the provincial courts now, but the major courts set out in our Constitution are the Supreme Courts and the appellate courts and the Supreme Court of Canada. So the peculiarity is that the federal government appoints those people who are judges and pays them, but the province has the responsibility for administration of justice. And there's so many burdens on provincial coffers, Medicare, health care, housing. I mean, you know, and people know, everybody knows how serious the challenges financially are. And guess what? I'm just making this up now, but it seems to me plausible that at the end of a cabinet meeting, they say to the Attorney General, and what do you think you need for the courts? And there isn't much left. So that's the sense I get. And I think if we actually put in some seed money, provinces did, and said, we're going to appoint some really smart people at organization and dispute resolution, and we're going to let them come up with some models of how we can make things better, and then how we can digitalize and all that. That would take a few $1 million, but it would be money well spent if it would result in a more efficient system. But instead of actually looking at our systems, and there are exceptions, I think Chief Justice Morowitz is doing a good job, and saying, what can we do better? We tend to just say, well, it's pretty good, it's not totally broken, and it's producing good results in those cases that get heard, and so we go forward without really reforming the access to justice problem.
And what you say really resonates, because I think it's more general issue with our democratic systems, which is if you look at our economies, how massively they've changed since the 19th century. If you look at a lot of social norms, conventions, practices, how much they've changed, but a lot of our institutional fabric of our political systems is the same. You know, there's a House of Commons, there's a Senate, and those things we want to keep, but innovation, there's a whole realm of democratic innovation, and the courts seem to be part of it.
I agree with that entirely, and you know, a young man said to me today, I was just chatting casually, and he said, well, you know, there's a feeling in the United States that the old Constitution isn't working anymore, and our institutions aren't working anymore, and we got to break things and make it new. That's exactly what you're saying. If we want to avoid breaking things, the better way is to innovate. To innovate more and to think more about how we could do things better at every level, including the courts.
Right.